Everyone. My name is Harsh and I am present here today to take a session on the historical background of the Right to Information Act of 2005 and the recent amendments which have taken place after the RTI Amendment Act 2019 was passed. Now when we talk about the historical backgrounds, we have to go back to the year 1975. In the year 1975, there was a very important case which we still refer in our constitutional subjects. The state of UP versus Rajnarayan. Now what happened in this case was that Mr. Rajnarayan filed a case of electoral malpractices against Mrs. Indira Gandhi, and he put on allegations that Mrs. Indira Gandhi was using malpractices in order to win the Lok Sabha elections against him. Now this case was filed in the High Court of Judicature at Allahabad, and while pronouncing the judgment of this case, Justice Jagmohan Lal Sinha found Mrs. Gandhi to be guilty of the charges which were pressed against her by Sri Rajnarayan ji, and Mrs. Indira Gandhi was imposed with a penalty, and she was also restrained by fighting any elections for the coming 6 years. As a reaction of this, in the next few days, the emergency was imposed in India on the grounds of internal disturbances by the then President of India. Now once we see the emergency was imposed, there was blatant violation of the rights, the fundamental rights as well, and various constitutional principles, the rule of law, and all these things were blatantly violated by the government, by the authorities that were functioning under the government. And for those who were using their freedom of speech and expression and such fundamental freedoms in order to express their views against such acts of the government, they were restrained, they were detained, and there were n number of cases which were filed on the charges of illegal detention of political leaders, of people, general people like you and me, who were trying to raise their voices against the government. Now subsequently after this, there were the 1977 Lok Sabha elections in the year 1977. Now in this particular election, Shri Morarji Desai, in his electoral manifesto, said that they want to bring a more transparent regime, they want to bring a more transparent system to ensure that the functions of the government, the functions of the administration are in many ways clear and within the authority that it should be, and it is that the systems of checks and balances and such constitutional principles are effectively maintained. So they basically talk about an open government. Now what is this open government that we are talking about? That basically means that there won't be any misuse of power, there won't be any arbitrary use of power, as we will be providing a proper transparent system that will be there to ensure the rights of the people. In order to fulfill the promises that they made in their election manifesto, they formulated a working committee. And the major function of this committee was to review that whether the Official Secrets Act of 1923 can be modified so as to ensure a more transparent system which have a greater flow of information. But the committee, while submitting its report, very clearly said that no, there is no scope of change, and it was somewhere shutting the doors for transparency and openness. Now what is this Official Secrets Act? It was formulated in the year 1923 by the Britishers, which we, our Constituent Assembly, retained after independence. The major function of this act is to govern acts like espionage, sedition, and such potential security threats to the national security of India. Now following this, in the year of 1986, there was another important case of Mr. Kulwal versus Jaipur Municipal Corporation, and the Supreme Court, while deciding this case, clearly said that the freedom of speech and expression as given to the citizens of this country under Article 19 very clearly implies that the freedom is not exercisable as long as we're not having a right to information. As long as I'm not aware of the government's actions, I cannot exercise my freedom of speech and expression. Now after this, in the year of 1989, the National Front government further shifted its commitment back to the right to information. Now this step of the government was basically an outcome of the people's frustration that they had over the reluctant act of government. And following this, in the year 1990, Shri VP Singh, heading the National Front government, stressed on the importance of right to information as the legislated right. And there were some initial efforts that were made in order to formulate a law. So in order to reintegrate his commitment, the Prime Minister VP Singh, in his first broadcast to the nation, very clearly said that we will have to ensure the access to information. We have to increase the access to information, and the government is to work in the full public view, and in such cases the wrongdoings of the government will be minimized. He also said that the Official Secrets Act will be amended and we will make a more transparent system which will ensure a free flow of information, and the right to information will be enshrined in our constitution. Now following this, we move on to the year 1994. Now in 1994, there was an organization named Mazdoor Kisan Shakti Sangathan. It was a Rajasthan based organization, and they basically started a grassroots level campaign in Rajasthan for the right to information. And they were majorly demanding information in regards to the developmental work which was being carried on for the rural sector of Rajasthan. And this movement subsequently grew a lot. And following this movement, the government of Rajasthan enacted a law on right to information in the year 2000. Now after this 1994 major incident, we move on to 1995. Now in the year 1995, the draft legislation was formulated in a meeting of social activists which was taken place in Mussoorie in the year 1995. Now the meeting took place in the Lal Bahadur Shastri National Academy of Administration, and there they tried to formulate a draft legislation. Now following this act, we move on to the year of 1996. Now we will say that what happened there. We move on to the 1996 and we see that there is an organization named NCPRI which is formed after the 1995 incident. Now what is NCPRI? NCPRI is basically a national campaign for people's right to information. Now NCPRI was formulated in the year of 1996, and after this the Press Council of India, under the guidance of its chairman Justice P.B. Sawant, were drafting a law which was later updated and changed at a workshop, and which was renamed as the Press Council NIRD Freedom of Information Act of 1997. In the year 1997, the working group was appointed by the Union Front government under the chairmanship of Mr. H.D. Shawdy, and they drafted a law basically which was called the Freedom of Information Bill of 1997. And following this, Tamil Nadu became the first ever state in India to pass a law which was regarding the right to information. And further on, in the similar year, we see Madhya Pradesh was trying to execute orders to some departments in order to ensure the right to information, which was further extended to more departments. And also, Goa passed its law on right to information in the very same year. Now after this, in the next year, that was 1998, the Prime Minister Shri Atal Bihari Vajpayee ji announced that we'll very soon have a right to information as a legislation in our country. And after this, the Madhya Pradesh government also tried to table a bill. The bill was successfully passed by the legislature, but it could not turn into a law as the governor denied consent to the particular law. Now after this, in the year 1999, there is a very important time. We see in the year 1999, Union Urban Affairs Minister, he passed on an administrative order on the transparency in the UA Ministry, Urban Affairs Ministry. And after this particular order being passed by the minister, the government restrains the minister. and as a result of which a PIL, a public interest litigation, was filed in the year 1999 in the Supreme Court asking for the lifting of restraint on the particular minister, and in order to declare that the Section 5 of the OS Act, the Official Secrets Act, was unconstitutional. And they also demanded that the government of India should be asked in order to issue suitable instruction for RTI pending legislation. Now, following this, we move on to the next year, which was the year 2000. Now, why was it so much important in the history of right to information? Because in this particular year, a bill was introduced in the parliament, that was the Freedom of Information Bill, and it was passed as the Freedom of Information Act and referred to a select committee of parliament. Now, after this, it took 2 years for the committee to submit its report in the year 2002. Now, after the committee submitted its report in the year 2002, the Freedom of Information Bill was passed in December 2002 by the end of the year. And following this, after a year in the 2003, we see that the both houses of the parliament have passed the act in 2002, and the act was notified in the Gazette in the year 2003. Now, subsequently, what happened in the year 2004 was that the UPA government came to power in the year 2004. Now, the UPA government, as it came into the power in 2004, they formulated a National Advisory Council, the NAC. And the major purpose of formulating the NAC was to monitor the implementation of the CES and to advise the government in order to formulate policies and laws. That was the major function of the National Advisory Council. Now, following this, as we talked about the NCPRI, the National Campaign for the Protection of People's Right to Information, they formulated amendments to the particular Freedom of Information Bill that was there in 2002, and they formulated this amendment, and they further forwarded these amendments to the National Advisory Council in the year 2004. Now, the NAC endorsed these minor changes, and these changes were recommended to the Prime Minister in the year of August 2004. Now, after this, they reported resistance from the section of civil services and politicians, and there were various efforts, massive lobbying which was being done by the citizens and the groups, and finally RTI bill was introduced by the government in the parliament in December 2004, which was applicable only to the government of India. Now, there was widespread protests which were going on in the country by different NGOs and some members of the NAC. There was widespread protests and movements going on within the entire country that we could very clearly see in that particular year. And after this, NAC was discussing the bill, and it was restraining the powers, and it was somewhere trying to support the original draft that was applicable to the states also. And further on, the bill was referred to the government, and after this, a huge lobbying was done by the citizens, and about, I believe, I don't remember the exact number, but it was somewhere about 150 amendments which were introduced by the government in that particular legislation, which was further formulated and forwarded by the National Advisory Council. There was 150 amendments which were done by the government, and after doing that, it was finally passed, and now it was also applicable to states, but not only to the government of India. And it's received the presidential assent on the 15th of June in the very same year. And further on, many reservations were expressed by the president, CBI, CVC, and the Delhi police. And progressively, we see that various states such as Tamil Nadu, Goa, Rajasthan, Karnataka, Madhya Pradesh, New Delhi, Maharashtra, and Odisha, many such states were progressively enacting their laws by that particular time. Now, this is what we mainly needed to discuss in the particular history of the Act. And by this we learn and we see how important it was for us to have a more transparent and open system of governance within our country, so that we can ensure that the problems that are pertaining in the governance, the issues that the governments are causing to the people, are somewhere minimized if we have the functioning of government open to the public view. Because as long as I am aware in a participatory democracy, I can participate and I can express my freedom of speech and expression more freely. And the participatory democracy, what does it mean? It means a democracy which involves more participation of people. And in a democracy, the participation of people is the basic essence. And people and the citizens cannot participate as long as they are not having an access to information. So the right to information enactment, followed by major steps by the different governments, by different organizations, by different individuals playing their important roles, enacted this particular legislation, which was in a way giving a huge transparency to the citizens, and it was regarded as one of the best steps in the year 2005 when it was enacted to protect the rights of the citizens, to protect the arbitrary use of power by the government, and to ensure that there is individual liberty which is present here. We still as citizens have the liberty to exercise our fundamental rights, and so that our rights are not blatantly violated by any government, any authority or any administration. The information is a currency that every citizen requires, that every citizen should possess in order to participate in the life and the governance of the society. Now, moving on to the amendments that we're going to talk about, the recent Amendment Act of 2019. Why is there so much fuss created about this amendment? Why are the former Chief Information Commissioners, the opposition, and a lot many people opposing these amendments? What is wrong with it? Or is it just a way of opposing so that they want to put down the other government? We will talk about this in this particular part of the session. So we will very quickly discuss about what all amendments have been done, and in the later part of the session we will discuss as to why these amendments are good or bad for the RTI Act of 2005. Now the amendments which were majorly brought were in the section 13. Beginning from it, we'll start from it. So the section 13 was originally talking about the term of Chief Information Commissioner and the Information Commissioner, and it was also talking about the salaries, the allowances and other terms of service of the Chief Information and Information Commissioners subsequently. Now what initially was enacted in the legislation was that the term of the Chief Information Commissioner and the Information Commissioner was to be 5 years or until the age of 65 years, whichever was earlier. And talking about the salaries and allowances and the other terms of service, they were said that it shall be similar as that of a chief election commissioner. Now what happens after this amendment? After this amendment, the appointment will be for such term as it may be prescribed by the central government. The appointment of the Chief Information Commissioner and the Information Commissioner shall be such as it shall be prescribed by the central government. And the salaries, the allowances and the other terms of services of the Chief Information Commissioner and the Information Commissioner shall be as prescribed by the central government. Now this is the difference which was brought earlier. It was either 5 years or 65 years of age, and the salaries and allowances were said to be in the accordance of Chief Election Commissioner. But now all of this is at the will of the central government. Now the another major amendment which was brought, it was in the section 16, which was the appointment of state level CICs and ICs, which is the Chief Information Commissioner and the Information Commissioner on the state levels. The earlier one was on the central level and now this one is on the state level. Now the proposed amendment is allowing the central government to control through different rules the terms and conditions of the appointment of commissioners in states. The amendment is in a way giving powers to the central government that by way of rules it can also influence the appointment of the commissioners in state. And it is somewhere empowering the central government to unilaterally decide the tenure, the salaries, the allowances and the other terms of services of both these commissioners under the center as well as the states. Now RTI is always a constant challenge for us because the law was enacted in order to ensure that there is no misuse of power, that there is no threat to arbitrariness, that we are putting a restraint on the privileges and the corrupt governance by the government. This was the major principle because of which it was introduced. And these amendments are in a way leading to the dismantling of the transparent mechanism, because these measures, these amendments, the rules that are being laid by the amendments are in a way taking away the arbitrariness of the act, because the appointments, the salaries, the allowances, all of these are being controlled by the central government now. The central government can decide the tenure, the central government can decide the salaries, the central government can decide the allowances, the central government can decide the terms of service. So we are in a way taking the autonomous and a transparent mechanism and we are shifting it towards a indirectly controlled mechanism which was going to be controlled by the central government, and which will in a way cause influences on those who will try to give away information if it is requested by any of the citizens of this country. Why? Why are these amendments being opposed so much? What is the major issue? The issue is that we are violating the basic principles of federalism. We as the people, we as the government are undermining the independence of the information commissioners under the Act, which was an autonomous body by them. We are diluting the system of transparency. Another major amendment which was done was the reductions in salary. Now what previously happened was that if at the time of appointment the Chief Information Commissioner or the Information Commissioner are receiving any kind of pension or any other retirement benefit from any government services previously that they were handling, in such cases their salaries will be reduced by the amount equal to that pension. If they are receiving any pension or any kind of benefits from their retirement from the previous government job, so that particular amount was to be deducted by the salary that they were going to receive now as the Chief Information or Information Commissioner. Now the current bill removes this provision of reductions in salary. There won't be any deductions, no matter whether you are receiving any pension, no matter whether you are receiving any retirement benefits, but your salary will not be deducted from what you are getting as the Chief Information or Information Commissioners. Now this, I won't like to make any opinion in favor of any of the political parties because I'm not here for that. I'm here to teach you guys. I'm here to tell you guys more about it. So there's a very small piece of opinion from the perspective of a law student, from the perspective of a person who is teaching you guys over here, that as long as we talk about a federal system, as long as we talk about a more transparent and autonomous system, we need to ensure that there is a separation of power. We need to ensure that there is an autonomy that is being given to the particular organ. And these are the basic things for which I believe the concept of separation of power or the checks and balances was introduced, so that we can ensure that there is no arbitrary use of power by any of the organs of the government, be it the executive, legislature or the judiciary. But the government, by the way of this amendment, from a legal perspective, we see it is trying to take away the federal character of the constitution. It is trying to take away the federal character that we have been enshrined with. And it is also taking away the transparency. So this has become a matter of dispute because we are not sure that are we really having a right to information, are we really having access, because I would not like to name those incidents here, but there have been various instances where there was information sorted which was asked by the people from the government, but it was denied. It was clearly denied on the grounds of national security. So we need to look more into the national securities law so that we can ensure as to what we should actually ask and what we shouldn't. And we shall try to make it a more autonomous body so that it can have the basic essence of it. The law was enacted with the basic essence to bring a transparent system. So if we are taking away the transparency, we are in a way failing the law. So we need to ensure that. And that will be all for our today's session. I'll soon have a session on the RTI Act and legislation soon. Till then, goodbye. Thank you so much.